Alex here with part 27 of the My Docket series on Corazon real estate. We're going into the motion to strike. I mentioned in the previous video that I would not have filed a supplementary, um, I guess I called it supplementary brief to motion or something like that. And this motion to strike is a response by the attorney to remove it. Using a motion to strike, it's just going to cost the client more money. I would have probably just filed it in the opposition. I don't know why attorneys love to do that. It triggers more filings, which means more money. I do think she's right. And no, wait, actually, huh. I guess the cheaper way to do it is with an objection. I mean, you could do this, it's just going to trigger even more motion practice. There's cheaper ways to deal with problems like this. And in this case, I guess because she's trying to remove a document from consideration, the cheapest way would be an objection, in my opinion. But this is the way they wanted to do it. The other thing that I wanted to mention, if there was a hearing coming up, they could bring it up then. They could say at the hearing that they object to it, they don't want it considered. And then the other thing I wanted to say is if the judge did consider it, you could probably use that as a basis for appeal to argue that since it was not properly filed with consistent with the rules, that the judge abused their discretion by considering it. So there's a lot of different ways to contest one of these documents without actually having to file a motion to strike, which I think a lot of attorneys are strike happy. There are some attorneys that are chill about it, and then there's others that are strike happy and they file motions to strike all over the place. I get that it wasn't supposed to be filed, but there's, I think, a more cost-effective way to deal with this problem than to trigger full briefing. Because when they file a motion to strike, then that forces the other side to file an opposition. And it's such a non-issue. Really, a lot of judges understand that they can't consider this stuff. If there was a hearing coming up, some of the judges will consider it as a certify and they'll just give the other side a chance to address it if they want to. Some judges will say, no, I'm not going to consider it. There's just ways to deal with it without billing your client so much money. In any event, let's go into it. Motion to strike by, oh wait, we need to actually stop for a second because this is where I cue that we're going to go into what Katherine Parks has filed. Here we have the motion to strike. Let's start from the top. Standard introductory paragraph indicating this document was filed by the attorney for Corazon Real Estate. So they're going through the briefing, which is the motion was filed, the opposition was filed, the reply was filed, they submitted it to court for consideration, and then I improperly filed a supplement to the opposition. Let's see. Continuing to argue the merits of the case, presenting additional evidence. Evident that plaintiff has filed supplementary brief in an attempt to gain an unfair advantage. I love how they use unfair advantage. It's a pretty standard fear of a pro se litigant to file a reply to anything that's filed. It's a standard instinct, which I say you kind of have to resist. And it's not really an attempt to get an advantage. It's just regular old non-attorney brain saying they filed stuff and they left things out, so I need to respond. But yes, she is right. I just have more understanding of how it's all supposed to work now, so I realize that now, whereas back then I didn't. Rule 12. Let's see. What does Rule 12 say? 5 additional days to file a reply. Upon expiration, somebody can request submission. The rule is simple. Circumventing WDCR 12 by filing a supplement cannot withstand scrutiny. It withstands scrutiny all the time. Different judges deal with it in different ways, especially in family court. But she's probably right that when you're outside the boundaries of family court, that it's much harder to get something like this to pass. Still, some judges will do it. Even if a judge will allow you to file and then consider an improper filing, it's not something that I recommend at all. You're just going to expose yourself to possible sanctions. If your judge in particular does not like pro se litigants, they'll just find ways to ruin you. So definitely watch my video on the topic self-representation bias, because that's a problem. In hindsight, again, same thing that I've been saying, I would not have filed this document. I'm still reading. Okay, yeah. So she's admitting that 12 sub F allows the court to strike pleadings. And that is true. There's logic behind why motions to strike a pleading make sense. They definitely make sense. If you strike a pleading, now you can default. There's a logical reason for the mechanism. But if you're trying to strike a non-pleading, it's just, in my opinion, a waste of your client's money, and deal with it in a different way that's cheaper. That's what I would do. If I was an attorney and somebody did that, I wouldn't file a motion to strike. Um, Willful disregard. This is another lie. Willful, no. Most non-attorneys are not purposefully disregarding the rules. They're just interpreting them incorrectly, or they don't know them. A standard attorney tactic, though, is they'll just say it. So she is bringing up the imposition of sanctions, which is a common attorney tactic. I talk about how to resist this in the video, defend against attorney fees. I'm surprised. I think there's another rule that I think she doesn't talk about SIR replies at all. I know that there's case law on this. She probably just couldn't find it. Rule 5, certificate of service indicating this document was mailed to me. Normally, guys, I would not combine all of the documents in one video, but because this is such a small potatoes type of issue, I went ahead and did that. We're just going to go through this very quickly. Here's my opposition to motion to strike. Standard introductory paragraph indicating I am appearing in proper person, which means I don't have an attorney. So I get that I'm saying that I didn't have an opportunity to respond because it wasn't delivered until after the opposition. Okay, so even if this is true, then I think the better way to deal with it is a motion seeking permission to file a SIR reply, or to urge the court to set a hearing so that I can bring up this additional stuff. I mean, it is a valid basis. If you get documentation or evidence that's relevant after the deadline of filing your particular document, the opposition, then there is logic behind why you should be having an opportunity to bring that to the court's attention, because it didn't exist back then. So it's not through negligence that you didn't bring it up. It's because it just plain didn't exist. But to just file a supplement without asking permission is not a good idea. So that's probably what I should have done. But I still don't think it's really that relevant. So I'm still going to go back to my original position, which is I probably just wouldn't file anything. So this isn't true. Just because they brought, well, okay, actually, I do have a valid point here too. When you're filing a reply, you're supposed to address the new matters that were set forth in the opposition. And so what I'm saying is that rather than her address the new things that I brought up in the opposition, she just created new things that she should have actually brought up in her initial motion. Okay, I can see that I'm saying that here. Yeah, that's another valid point, but you still have to ask permission. Or use the hearing. Sometimes they'll just set a hearing and then you don't have to ask permission. You can just bring up all this stuff at the hearing. That's totally allowed. So yeah, there are better ways for me to confront these issues, but just filing a supplement without asking permission is not the way to do it. Sanctions are not appropriate. I'm bringing up the fact that you have to raise arguments, otherwise they're waived. This is true, but I mean, this is still, you don't need to file. I didn't need to file that, or at least not without asking permission. They filed a motion to strike in violation of WDCR 10 sub 9. Why? Any motion, opposition, or reply must be filed as a separate document unless it is pleaded in the alternative. Oh, this is okay. Yeah, so I'm saying that she broke some rule at some other point in time. You can do that if you really want to, but the courts don't care. They're going to look at what's going on right in front of them right now. If you bring up that the other side has broken a bunch of rules in the past and therefore you're okay for breaking a rule, I might go somewhere with some judges, but if you're a non-attorney, most likely you're going to see self-representation bias. Legal theory, strict construction of the court's rules have some merit, fails to recognize the reality that occasionally a rule will conflict with case law or constitutional principles. I mean, I guess what I'm insinuating here is possibly due process, which would be true. Rule 11 is the appropriate vehicle to deal with a violation of court rules. And then, of course, this has a safe harbor provision. which would have allowed me, if I was going to bring this up, then I would have withdrawn the supplement. What I would have done is I would have filed this opposition to strike. I would have cited Rule 11. I would have withdrawn the supplement, but, I didn't know this stuff at the time. Safe harbor provision, what that is it's a way for you to avoid the punishment by just saying, okay, I'm going to just back off. That's actually built into Rule 11. Oh yeah, look, I mentioned it here. Motions to strike are more appropriate when they serve a functional purpose, such as the negation of a filed answer. I was just talking about this. So I understood this even back then. Rule 5 certificate of service indicating this was mailed to the attorney. Next document, reply. So yeah, this is what I was talking about. It's just triggering more filings, which is going to trigger more billing for their client. Evident that I filed a supplement to attempt to gain an unfair advantage. She's just repeating, she's regurgitating what she said on opposition. I'm going to scroll through this, guys, and see if there's anything new. There's nothing new. She's just putting all of the same laws in there. She's adding a few. This isn't really that complicated of an issue. As I mentioned, most likely there's no basis to file that, especially without permission. So this is a lot of work on reply for such a small issue. And then the request for sanctions. That's everything. Rule 5 certificate of service indicating this document was mailed to me. Guys, I would have talked more about that, but it was the same. She was just rehashing the same thing. Rules don't allow it. Rules don't allow it. It has to be stricken. Rules don't allow it. And then she brought up some case law. So it's true. The rules don't allow it. Shouldn't have been filed. That's it. And now this is just the really ad nauseum way to go through it. Request for submission. This is them submitting to consideration, to the court's consideration, the motion to strike. And if you guys want to learn more about the request for submission, please watch my video on the topic, request for submission. Rule 5 certificate of service indicating this was mailed to me. Next document. Order to set hearing. Okay, so the judge is setting a hearing on the opposition to motion for judgment on the reply in support. The court believes a hearing would be appropriate to assist the court in its decision. The court requests both parties present oral arguments on the motion and other ripe dispositive motions at the time of the hearing. So he basically didn't even really listen. Well, it's basically he wants to deal with it at the hearing. Okay, guys, if you want to learn more about, actually, hold on a second. I'm going to talk about it with the next document. Certificate of service indicating this document was mailed to both. Well, this document was mailed to me and electronically served on the attorney. Then we have the notice to set. This is what I was going to talk about. I did a video on this very recently. The video is called Hearings. The process for setting is mentioned in that video, and it's important, and it's a little bit tricky, complicated, confusing, etc. Basically, there's notice. Wait, what? This isn't a notice to set. This is a notice of hearing. Where's the notice to set? Hold on, guys. Let me look at something really quick. Oh, so he didn't even ask for he didn't ask for a notice to set. He just asked us to confer and set a date. So, I mean, that's kind of like a notice to set, but less strict. So he had me call them. Then we all group called the clerk, and then we talked with the clerk, found the best time that was available for the court and for everybody, and we set this hearing date. And that is January 8th at 1:30 p.m. I think that's everything. Okay, so we got a Rule 5 certificate of service indicating this document was mailed to me and the arbitrator. Why would they? I forgot about the arbitrations. Maybe I'll talk about that next video. There's a lot of things in this case that I forgot about. So next video, I'll talk more about the arbitrations and the hearing itself. Going into the aftermath, I filed one document, and it was a free filing, so I incurred $0 in costs. The Corazon Real Estate filed 4 documents. They were all free filings, so they incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. They would have incurred on the motion an hour, on the reply 2 hours, so we're looking at 3 hours. Then they would have had to put some time into reviewing my opposition and the court's order, and then work with me over the phone on setting the hearing. So I'm going to just tack on another hour. So we're looking at 4 hours at the rate of $250 an hour. That's going to come to $1,000 in attorney fees for Corazon Real Estate. As for my previous video, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.